Good morning, everyone. Welcome to our live Q&A webinar on New Zealand employment law updates. My name is Ben Thompson. I'm the CEO and co-founder of Employment Hero, and I'm also an old employment lawyer. The bit of background just before we get into it. Employment Hero was created because as an employment lawyer, I just saw the difficulties that small and medium-sized business owners were experiencing, understanding the employment laws and how to be the best possible employers. Realized that people were really living in a state of anxiety around all of the burden that comes with being an employer. And I couldn't fix it as an employment lawyer. So I went the other way and focused on building technology that helped digitize employment and make it really easy to manage. And so that's the legacy behind Employment Hero. But obviously, employment law is always changing, and our legacy is sort of built into our platform and our partnerships. So we're really proud to be working with other lawyers, Martelli McKegg in New Zealand, to keep our customers and business owners informed of the changes, the coming changes, and the live environment that is employment law. So today I'm joined by Claire Mansell, Senior Associate at Martelli McKegg, and Mathew Martin, Associate at Martelli McKegg. If you're both there, thank you very much for joining us. I really appreciate you giving us your time and knowledge to help guide people through some pretty major changes to New Zealand employment law.
Thanks, Ben. We're really happy to be here today.
Yeah, good to be here.
Well, thanks again. So this is a live Q&A session. At the end of this session, we will have live Q&A given time. During the session, we're covering a lot of content, which I'll explain in a minute, but do feel free to post questions into the Q&A or to the Q&A section at the bottom right-hand side of the Zoom screen. If possible, we'll answer those questions on the fly as we move through the presentation. Anything we don't get to, we'll come to at the end or try to come to at the end. And then following our webinar, we will be sending out a copy of the recording and some other information that addresses those questions we didn't get to. We will, just also need to note a disclaimer. The information in this webinar is not legal advice. This is general opinion. It's provided in good faith. We don't accept liability for any of the views that are expressed on the webinar. If you do have specific issues that you would like to get or need to get expert opinion on, please do. And obviously, Claire and Mathew are incredibly capable. So please follow up with them if there are any issues following the webinar. So today, I just want to talk you through what we're covering. As I said, there's been a lot of change and there's a lot of potential change coming to the New Zealand employment laws. Firstly, changes to the Holiday Act 2003, including changes to sick leave, bereavement leave, and Matariki. Minimum wage increases and what you can expect over the next 24 months. The next one is fair pay agreements. I think this is a pretty chunky one. What are they and how do they affect small businesses? When are they likely to become a reality? And then the income insurance scheme and how it will affect employers. So with all that said, I would happily pass to Claire and Mathew for their presentation. Thank you.
Hi, thanks, Ben. Right, well, the first topic we'll be talking about today is the changes to the Holidays Act. Now, most people will be pretty familiar with this concept that there is going to be major changes to the Holidays Act. Some of those changes are already in place, and we're expecting more to come in next year. Now, why this is happening? Well, for most people who have dealt with the Holidays Act, most employers will know it is a bit of a dog's breakfast. It is a very difficult piece of legislation to get your head around. Even experts have got it wrong. Some of the big accounting firms have whole teams just dedicated to the Holidays Act because it's so complex. And it's really just not fit for purpose anymore, particularly with the changes to employment, people working different hours. We're not in a situation where most people just work 9 to 5, 40 hours a week. So when the Labor government came in, one of their mandates was that they would look into the Holidays Act and make it easier and fit for purpose. They created the Holidays Act Task Force, which was headed by Jim Bolger, our former PM. And the task force gave a whole bunch of recommendations, which have all been accepted by the government. So we should see these changes come in. I checked this morning and it's been updated to the start of next year. So that's the idea when they'll come through. So if we just hop on to the next slide. So there's a load of things that are going to be changed when this legislation comes in probably next year. But I've just picked out probably the 6 most important changes because they're the ones that will be most relevant for employers. The first big change is going to be the way that annual leave accrues. So this is how employees become entitled to annual leave. Now, at the moment, you've got your 4 weeks and employees become entitled to the 4 weeks at the 12-month anniversary. That's all well and good, but that doesn't really take into account the realities of, employees' lives. Most people will find it pretty hard to go a full 12 months without taking a holiday if things come up that they need to take holidays for. And there's also the problems with close down periods. So for some of you out there who have a close down period, that's where you close generally over Christmas, you be aware that there are some complex arrangements in terms of when you require employees to take holidays if they're not if they're still in their first year. And it gets really confusing because you have to reset the anniversary date and it's just a bit of a nightmare, to be honest. So the idea is that we'll remove that. You will be able to take annual leave in advance on a pro-rata basis, which frankly, that's what happens already. And also, they're going to remove the pay-as-you-go annual leave for fixed-term employees. So this was an exception where fixed-term employees for less than 12 months would get paid an extra 8% on top of their normal earnings, and they wouldn't be entitled to annual leave. So now they will just incur annual leave or accrue, annual leave on a pro-rata basis throughout their employment. So it's going to be a pretty practical change. It's probably going to reflect what a lot of businesses do in practice anyway, and it's just aligning the legislation with what actually happens. The next big change is going to be to the way that we pay annual leave. So when you pay out annual leave, for employees that earn regular wages, it's really easy to work out. If you are an employee or you have employees that work variable hours, they have things like commission and bonuses. It gets really confusing because the calculations for how to pay annual leave are really confusing. There's a lot of disagreement about how they actually apply, and some of you will be aware that even Datacom, which is one of the biggest payroll companies here, got it wrong. And there are companies out there with millions of dollars in miscalculated annual leave. So to avoid this nightmare, the task force proposed to change the way that we calculate annual leave. The problem is that they didn't really change it that much. Now they're just saying that, all payments made under the employment agreement need to be taken into account when you calculate annual leave, which is pretty similar to what the situation is here. At the moment, you can exclude discretionary payments like bonuses. And you'll be looking at, there'll be a 3-stage test to see how annual leave is calculated. I'm not going to go through it here because it is actually still really complex. So what you will need to know as business owners is that you will need some kind of software provider to do this for you. It's quite complex. There's different scenarios. If you calculate it one way and it's more, then you go with that. So to avoid any kind of miscalculation, I really recommend that you look into, if you haven't got it already, some kind of software provider to do this for you. There's also going to be changes to sick leave and family violence leave. and bereavement leave, and employees will be able to be entitled to this kind of leave from the start of employment. And that recognises the fact that, you know, you're going to need sick leave early. You know, you're not going to wait 6 months to get sick. Some people get sick early on in their employment, likewise with bereavement and family violence leave. They're going to remove the parental leave override for annual leave. Now, this may mean that employers pay a lot more in annual leave for employees that are returning from parental leave. At the moment, what happens is when you go on parental leave for your 12 months or however long you go for, you still accrue annual leave during that time frame. So if I've been away for a year, that year I'm away, I still accrue 4 weeks of annual leave. Of course, I'm not taking any of that leave because I'm not at work anyway. So when I come back from parental leave, I have this, you know, this big lot of annual leave. Now, that can seem a little bit unfair to employers because they've just let you be, you know, away for a year and now you're got 4 weeks annual leave. So to balance that, what happens is that for any annual leave that an employee takes in the first year after they come back from parental leave, when you pay it, you look at the earnings over the last 12 months, and that will include the period that you weren't earning anything. So the practical reality is that when you make payments to employees who've returned from parental leave, they're actually at a much lower rate, and that kind of balances the fact that this employee's just accrued 4 weeks leave. So that's going. So that's going to be a real, I think, a real issue for small businesses, particularly if you haven't got many employees and 4 weeks, annual leave is actually quite a big deal to you. Bereavement leave will be expanded, so it will take into account more family members, including cultural family groups. We don't know quite what that will look like just yet. And also there'll be greater transparency in pay slips, so you'll have to declare, how much sick leave people have, employees have. That's something that hasn't been required to date. So the idea being
sorry, Claire, sorry to jump in here, but just before we continue into this point on sick and bereavement and family leave, back onto the new calculation says 3 people asked the same question, so I just think it would be worth clarifying whether or not the PAYG 8% annual leave will be removed for casual staff.
It hasn't been addressed in this task force document. The problem with casual staff is that they don't actually exist in legislation. So there's no piece of legislation that says this is what a casual looks like. It's all come from case law. So we've got this kind of real situation where we have casuals and we use them and we pay them 8% because it's technically a number of short-term, fixed-term, employment engagements. Because every time you get a casual, it's a new employment agreement. So, and once they finish working for you in a day or a week or 2 weeks or however long, then that employment agreement comes to an end, that employment relationship comes to an end, and then starts up again next time you engage them. So what's happened is that people have just assumed, okay, 8% goes on top because it's a short fixed term arrangement. That issue hasn't actually been addressed, so it will be interesting to see how the courts approach this issue, because if you've only got someone working for you for, like, say, a week, and how much annual leave are they going to accrue? Do you pay that out at the end? These kind of questions haven't really been fleshed out. And remember, this isn't legislation yet, and we're still going through a select committee process, and these kind of issues will be fleshed out, and hopefully we'll have an answer to you. But it may be that you might have to pay annual leave to casual employees. It's going to be incredibly difficult to pinpoint when the relationship or the employment agreement comes to an end, because you don't know. The nature of casuals is that you don't actually know when they're going to be working from day to day. So it's a problem, and it's a really good question, and unfortunately I can't give you a definitive answer because I don't think the legislation is actually.
That's fine. Thank you very much. And just again, when was it likely to commence? Somebody missed the start. It was January 2023. Was that what I?
It started 2023. It was supposed to be mid 2022, but it's been pushed out. So watch the space is all I can say. You know, I assume that it will the government will want to push it through before the election.
Yeah. Okay, great. Sorry for interrupting you.
Sorry, no worries.
So we got to greater transparency.
Yeah, so
perhaps we can flick over
Yeah,
to the
yeah,
next
yeah.
slide.
Okay, so these will be the changes that most of you will be pretty familiar with now. Matariki, we had our first Matariki day a couple of weeks ago. It'll shift each year, as you all probably know, and it'll most likely fall somewhere in June or July, and will always fall on a Friday. And I understand that that's because the person that was one of the consultants when they proposed the Matariki just decided that, you know, there's not enough public holidays on a Friday, so there you go. Sick leave, 10 days. I understand that this has been a bit of a killer for businesses this winter, with pretty much everyone being down with illness. I know that yesterday I think we had half of our team away with different, you know, illnesses. So yeah, I think that this has been really, really hard for employers. And bereavement leave has been changed. So now I think we're the first in the world. We have bereavement leave for miscarriage. So it applies to miscarriage and stillbirth, and it's available to employees who obviously suffer a miscarriage or stillbirth, their partner, and also the ex-partner if they've, but you know, biological parent of that baby. So.
And is the sick leave? Someone's asked this question. Is the sick leave accessible from commencement, or is it also accrued throughout the year? Do they get the 10 years up front? No, sorry, 10 days up front?
So at the moment, the 10 days comes in after 6 months because we're under the old regime. Under the new regime, you will get it on a pro rata basis until 6 months, and then it will come in. Right. So you get, you know, bits and pieces, and then the 10 days will, you know, the rest of it will come in at the 6 month mark.
Great, thank you. Okay, before we move into the next section, we have a poll. Are you ready for the new Holidays Act changes? It sounds like they're not even finalised yet, but please let us know if you can give us an answer in this poll, and then we can put it up on screen. Just give that another couple of seconds. Well, 50-50, right down the middle. Still plenty of uncertainty. Half the people don't feel prepared. Okay, well, let's move into the next section, the minimum wage changes.
Yeah, perfect. Thanks, Ben. So, I mean, most of you will already be on top of all this, given the changes already come through on the 1st of April, but the minimum wage has gone up to $21.20 an hour. Another one to flag is the starting out and training minimum wage, and that's increased to $16.96 an hour. It might not have too much application for most of the employers on this webinar today. But you know, minimum wage rates apply to all employees aged 16 and over, and that's people who are full-time, part-time, fixed term, casual, or working from home. And they apply to all hours worked with no minimum hours requirements. And minimum wage rates are set by the government and reviewed each year. So it'd be interesting to see what happens, especially with the way inflation is going at the moment. Another discussion Claire and I had before we got in today was our next topic on the fair pay agreements and how minimum wage rates are going to sit in circumstances where you may work or employ in an industry where a fair pay agreement comes into place. So very much watch this space and keeping an eye on how minimum wage rates might apply to your business. So we'll flick on over on that basis. And
Yeah.
Claire, do you want to kick us off
Sure.
talking about fair pay agreements?
So fair pay agreements, this will probably be one of the biggest changes to employment law in my career. It's going to fundamentally change the way that employers interact with their staff and set the terms of employment. So in New Zealand, we don't have a very unionised workforce. Most employers won't have anything to do with unions, apart from some bigger employers and some specific industries. Obviously, like doctors and nurses and things like that. And the Fair Pay Agreement bill is going to change that fundamentally, because, like it or not, employers and employees will be dragged into these fair pay agreements. Now, why are we introducing this? Well, the theory goes is that New Zealand has low wages and we need to drive them up. So the Fair Pay Agreement bill proposes that in certain sectors and industries where there is a threshold is met, the unions will be able to force bargaining, and employers in that industry or sector will be forced into bargaining. And if there's no agreement, then the ERA will make a decision. And the idea is that this will drive up wages, it will drive up better conditions of employment, and we'll all be better off. Whether that happens or not is yet to be seen. Fair pay agreements are really targeting those lower wage industries. So the fair pay agreement we've got at the moment is for carers, home carers. But if you're looking at supermarket workers, security guards, anyone that's in a low paid job where they don't have much bargaining power, where there's not much room for progression, that's the kind of industry that these agreements will target. And that's going to target a lot of small to medium businesses. So it's going to have a massive effect. Ben asked before we started, well, what do you think is going to happen with this? I don't know whether it's going to stay as legislation. It's going to fundamentally change the way that we do things, but whether it will be long lasting is a different question, because if we get a different government, they might chuck this out by lunchtime, as they say. So that's the sort of, I guess, political background to these agreements, and I will let Matt fill you in on the details.
Yeah, right. So looking over to the next slide to start and how this process is actually going to work. So what happens is really unions take the first step in terms of initiating the fair pay agreement process. And so what they have to do is they have to basically gather together a grouping of around 10% of the employees in a particular occupation or industry, or 1,000 workers in the proposed coverage area. In addition to that, they can also establish a public interest test as met. And so in practical terms, what that means is it's the union going around gathering up evidence to show that they can get those numbers together, or that there are particular public interests concerned which justify the imposition of a fair pay agreement in a particular industry or occupation. They send that information off to the Ministry of Business, Innovation and Employment, MBIE, and if MBIE is satisfied, then really the process starts. Yeah, it's certainly much more of a role that the union's playing, and particularly the government, MBIE, having a real clear role in saying, okay, is there a justification, is the base criteria met to start the fair pay agreement process?
The public interest criteria will look at things like I've talked about before. So that's, low pay, minimal bargaining power, minimal opportunity to progress. Those are the things that will be, need to be satisfied if the union can't satisfy the 10% or the 1,000 workers. So there will be industries that they will already have in mind that will, meet that public interest test. So that's what we might see happening as a first step, I think. Yeah, exactly.
So then, as part of that process, one of the things they have to do is define coverage. So it is up to the union that starts or initiates the bargaining to define what that coverage is. And so the MBIE has a role in making sure that the coverage is expressed with sufficient clarity, so we actually know where it's being applied. And generally, and the way the bill's structured at the moment is it looks to both occupation-based agreements and industry-based agreements. So the bill provides the example of a occupation-based agreement, say commercial cleaners. So that's people in a particular occupation over which the fair pay agreement could provide. For an industry-based agreement, they give the example of butchers and bakers in the supermarket and grocery industry. So that's people in very different occupations, but working within the same industry as part of the same coverage area under that fair pay agreement. So yeah, again, it's that role that NDIE is going to play, and particularly when it starts to get complicated about competing fair pay agreements applying to one or two more industries or occupations, how that will apply.
And also the coverage may change throughout the bargaining process. So it may be, better defined, or it may be expanded. If that happens, then more parties may join the bargaining and they'll be notified, which we'll talk about next.
Yeah, that's right. And so notification is a really a key part of the framework that's been set up at the moment. So employers, unions, business representatives, the government as well, they each have their own obligations for notifying both employers and employees who might come under the coverage areas. So, one of the pieces of the framework for employers is providing their employee details to unions so that the unions can work with those employees as part of that process. It's a quirk of the system because obviously these fair pay agreements will apply to non-unionised workers, so people who otherwise wouldn't have any contact with their unions. And there's penalties in there if those notification obligations aren't met. So there's very much an onus on each of these parties to make sure it's meeting their obligations to communicate the fact that this is happening and making sure people can engage in the process.
But I think there's a real risk that some employers may be missed.
That's right. That's right. And again, it's because this the fact that it can apply to industries, it's probably pulling in a lot more small to medium employers than a lot of the existing union agreements, collective agreements actually apply at the moment. So you start the process, we move to bargaining, and once the parties have been notified, the process begins. Generally, the setup is that unions will represent the employees, while employers will be able to choose representatives who meet specific requirements. Again, there's a process where you have to go through MBIE to certify that the representatives acting for employers are properly authorised and able to represent their interests. And the fair pay agreements will cover all employees and employers within the coverage area. So again, it's why there's so much importance placed on a proper explanation of the coverage. Who will this agreement actually apply to? Now, there are some carve-outs for businesses that have significant financial hardship. There's also some discussion in the Cabinet paper around financial support for both employee and employer groups in bargaining. It's again intended to be pretty limited, because the idea is to try and facilitate this process as quickly, as efficiently as possible, if that is possible, but taking into account those kinds of factors. And so there's a lot that the fair pay agreements can take into account. They can take into account regional differences and other differential terms, so long as they ensure they comply with minimum requirements like the Human Rights Act. So there's a set of criteria of things that in a fair pay agreement the parties have to agree, and some of the things that they have to discuss. All fair pay agreements, they have to cover base wage rates, ordinary hours, overtime, and penalty rates. So at the end of the bargaining process, the expectation is that the parties will have agreed those terms. But other terms like redundancy, leave, health and safety, other criteria, those are things that the parties are required to discuss during the bargaining process, but there's no inherent requirement to agree on any particular terms. So moving over to finalising the fair pay agreement. So again, it's this unique role that the ERA is now going to play in the bargaining process. So before any fair pay agreement is finalised, it gets sent to the ERA to review, basically to vet it, before it goes to a vote of the employees and employers whether to accept it. And so the ERA's role there is to ensure that, first of all, that it has all of the minimum terms that are required under whatever the legislation will be ultimately, and making sure that there's no unlawful terms in there, anything that is not meeting those minimum requirements or breaching of some legislation or something along those lines. And so then if the bargaining parties do reach agreement, the agreement needs to be ratified by a majority of both employees and employers. So it's a voting system. Employees have one vote each, and employers, I'll put a little caveat on this, have one vote each. There's a weighting system that's been given to small employers, small to medium employers, up to about 20, where for every one employee they get 2. It's a graduating scale down and reflects the lack of bargaining power that small to medium employers might have in these circumstances. And then once the vote's done, and assuming it's ratified and agreed to, then again, government takes a role. It has to bring the fair pay agreement into force through secondary legislation. The reason for that is obviously there's parties to these fair pay agreements who aren't union members and have no contractual relationship necessarily between the parties that are negotiating and having these terms. So it's very much government intervention into employment contracts across industries, across sectors. So it's very much a much greater role for the government and much greater role for the ERA in determining what the terms and conditions of employment in particular sectors are.
Because what
Hey, Mathew, oh,
Yeah.
sorry. As an ex-employment lawyer, I just want to clarify one thing. The voting process, you mentioned that each employee has one vote and the employers have one vote for each employee. So, sorry, just trying to think through that. If you have 100 employees, does the employer have 100 votes and the employees have 100 votes? Therefore, you're 50-50 if everyone voted in favour or against. If the employer voted against and every employee voted in favour, you've got a 50-50, well, you don't have a majority. Is it just a simple majority? Like what is the, in practice, how does that work when an employer has an equal number of votes to the employees?
Sure, yeah. So it actually goes both ways, that both the employer side and the employee side each need to approve by simple majority. So it's not a count of the total employer. It's the employees need to approve it on their side and the employers need to approve it on their side.
Right. So this is where we're talking about coverage in a certain area more likely than one individual business. So if in that scenario, let's say that a union came to an area in New Zealand and looked for coverage of fast food industry, for example, they went to all the fast food businesses and they said, this is what we're proposing. There's 50 employers, that's 50 votes, but there's 5,000 employees, that's 5,000 votes. So you need to have a majority of the 50 employers approve it and a majority of the 5,000 employees approve it before it goes to get ratified. And if in that scenario, if the employers don't want to be covered and so they don't approve it, which is common here in Australia, I don't think many employers would ever voluntarily sort of walk into one of these agreements. But here in Australia, I think you'd just see that employers just don't approve it, so you'd never get the employer approval part. What happens then if there's not approval by both parties? Is that where it goes and gets mediated or arbitrated?
Yeah, it'll go to mediation first, but if there's still no resolution, then it will go to the ERA to make a determination. And I guess this is the reason why, if you're an employer, you might be willing to agree to this, because a bit of the devil you know, right? So either you agree to this agreement, or potentially the ERA will come up with something worse for you. So that's the rub, you know. If you can't just not agree and then hope it will go away. If you don't agree, eventually the ERA will make a decision. And do you want somebody who potentially doesn't have any experience in your sector, doesn't really know the industry that well, making decisions like this? That's the question that businesses are going to have to ask themselves.
Yeah. Somebody asked, will this be similar to the award system in Australia? I presume, you know, do you have any idea what unions will attempt to include in agreements? Can you imagine penalty rates and loadings and allowances and that level of complexity that we have in modern awards in Australia coming into these agreements? Is that the intention?
Yeah, well, I think it will start looking very similar to collective agreements that we have already in the industries that are unionised. So that's, yeah, overtime rates, penalty rates, all that sort of thing. And the more that this goes on, the more complex it will get. I'm sure that unions are talking to their Australian counterparts to see what happens over there, because you're right, it is very similar. I think the biggest difference is the ERA having the power to determine it. I don't think you have that in Australia. Is that right, Ben?
Not really. Yeah, arbitration sort of has gone out the window, but well, not entirely, but yeah, our system is sort of went this way, and then it just broke down, and now, because you can't be forced to make an agreement, there are just very few agreements being made. So yeah, our system is pretty much in deep freeze at the moment. But anyway, let's continue on. Thank you for that.
No, that's all good. All right. So yeah, look, yeah, what's next? Yeah, clear.
So it's at select committee stage. So if you want to give feedback, if you've got a strong opinion about this, you can give feedback. And then the select committee will report back to Parliament in early October 2022. It's expected that this will come into law at the end of 2022, maybe early 2023. See how things go. So it's not law yet. There's still opportunity to change it, but I think that it's very likely that this will come into law before the next election. Whether it stays, who knows?
Okay. Do you think next poll, if you could let us know, do you think you'll be covered by a fair pay agreement in future? Just keen to understand how many people are sort of worried or preparing for this legislation. Just give it a few more seconds. And also, if you've asked a question, I can see that we've got 13 questions that have backlogged. We will have a Q&A section at the end, so we'll try and make our way through those at the end. Okay, those are the answers to the poll. 29% of people do believe they'll be covered, 41% no, and 30% unsure. So yeah, a bit of a mixed bag. It will be very interesting to see, and as Claire said, I think this is a really significant change that we all should be paying a lot of attention to. Okay, moving on.
So another really big change, if it comes into force, will be the New Zealand Income Insurance Scheme. So this is not legislation. It's not even going through the parliamentary process at the moment. It's just an idea. So it may or may not come to fruition, but it's on the horizon potentially. So it's good to have a heads up about what this is all about. So as you all remember, COVID and the government with the wage subsidy scheme paid a lot of money to keep people in employment and to really smooth the bumps of financial hardship for a lot of employers and employees. And that's not the first time that's happened. Similar schemes were put in place after the Christchurch earthquakes. And Grant Robertson, who's, this is his baby, he was, of the mindset that when, big drops in people's income is not good for the economy overall, and we should have some way of smoothing out the bumps. And this is what they've come up with, is the New Zealand Income Insurance Scheme. Now, a really curious thing about New Zealand is that we have a lot of pro-employee legislation, but one thing we don't have is the statutory right to redundancy compensation, which is quite different in Australia. So when employees are made redundant, they're often left without income, and then there's a stand-down period, and the benefits are not what most people would earn. So there's a significant drop in income. A lot of people have income insurance to protect against this, but that's not everybody does. So when you have these big sort of economic upheavals, you have a lot of people with a sudden drop in income, and that has other pressures on the economy, people have less spending ability and whatnot. It also means that people often will take jobs which they're not really suited to or don't really want because they need the money. So the idea behind the scheme is that it just gives a little bit of cushioning after losing a job, so that people aren't without income for long periods of time, and it allows them to retrain or get into better employment, not just take the first job that comes along. And this in turn helps keep the wheels of the economy turning, and the theory is that we'll all benefit from this. So what does it all mean, and how is it all going to work? We just pop to the next slide. So it's basically a government-run income insurance scheme. A little bit like how ACC is a government-run, personal injury insurance scheme. Everyone will have to be part of it, and we'll pay for it through levies. So most employees will be covered by the scheme. It'll incorporate what we call non-standard employment arrangements. So that's your fixed-term employees, casual employees. It also may be expanded to sole traders or independent contractors. We know that there are a lot of workers who aren't technically employees, although, for all other purposes they are. So if you think about the building industry, a lot of builders are on independent contract agreements, even though they just contract to one company. So hope, the hope is that those people will come under the scheme, because if they lose that income, they're going to be put in the same position as if they were an employee. And what it's going to cover is a situation where an employee loses their job due to redundancy or health conditions or disabilities. So it's not going to be for misconduct. If you are terminated from your job because you've committed misconduct or you've been a poor performer, you're not going to be part of this. It's for no fault terminations. So where employees have lost their job through no fault of their own. And what will happen is that employers will have to pay a 4-week notice period if they don't already, but that's pretty standard for most people in New Zealand, a 4-week notice period, and a 4-week payment at 80% of their salaries. Then the government kicks in, you get a further 6 months support from a scheme at 80% of your salary or wages, which, as we all know, that's the rate for ACC. Just like ACC, it'll be funded through levies, so it'll be about 1.39% of your employee's salary or wages, and that'll be the employer and the employee chipping in. And there will also be case management services and support for the return to work, or for training, or whatever else you want to do. There are obligations on employees that they have to be actively looking for work or actively retraining. You can't just be like, oh great, I'm going to sit on 80% of my salary for 6 months and have a holiday. You've got to be looking to take that next step, whether that to be into a new role or for training. So it's still very much a proposal. If you've got strong views on this, again, Select Committee is the place to express those concerns or support or whatnot. And we don't know, this is unlikely, very, very unlikely to come into force this term. So it may be an issue that you might hear about during the election campaigns, I imagine. So yeah, very much pie in the sky, it's just an idea, but it pays to think about it in terms of, what might be coming on the horizon. As an employment lawyer, some of the concerns I have around it is that what I think will happen is that there will be more settlement agreements where employees and employers state that the person has been made redundant when really there's performance issues or misconduct issues, so that employees will have access to that to that money, to that those payments. So that's a real concern for me. I think it can be easily misused and will be misused. But that's just, that's
I mean, again, it does represent a pretty fundamental change in the way our employment law landscape works. I mean, you find most people are quite surprised to know that there's no obligation in New Zealand to pay redundancy compensation, right? It's a very common question you get. So this is really, again, imposing that on employers and those sorts of things. So there is the potential for employers to have ongoing costs, right?
Yeah.
They have to pay the 4 weeks upfront after the notice period.
I think one of the objectives of the scheme is to put more pressure on employers not to just resort to redundancy as the first option to remove staff. And that, I mean, I can tell you from experience, employers ring me all the time and say, I want to get rid of this person, they're not the right fit. Can we just make them redundant? This will mean that if you do that, then you will have to pay 4 weeks notice if that's not what you have to pay already under your employment agreement, but this additional 4 weeks at 80%. So things to think about.
But with that, when you say that they'd have to pay the additional notice, sorry, while I'm asking this question, we've just put up the third poll, do you think the income insurance scheme is a good idea? But just while people are answering, just to clarify that, if I'm an employer and I make somebody redundant, do I need to pay them the 4 weeks notice and the additional, or am I just paying a levy, the 1% levy that you mentioned, always on everybody's salaries? Like, how does it both, right? Yeah. So you're paying the levy for so it's forcing wages up.
Yeah,
1.39% or whatever it was.
Yeah. So it's forcing wages up. The wage bill for employers will go up by 1.39%, but also employees are chipping at 1.39% as well. So their real wages will go down.
Yeah. But then, so you're paying the levy, but then the employer still has to pay the notice period anyway.
Yeah.
Right.
So notice period will be a minimum of 4 weeks. I mean, that's pretty standard these days, 4 weeks, particularly in professional industries. But then you'll have to pay an additional 4 weeks at 80%, which is something completely new.
Yeah.
And the levy. So there's a lot of costs going on the employer. But I guess the flip side of that is this better than paying redundancy compensation, like you would in, other jurisdictions? Yeah,
like here in Australia, you'd pay 6 weeks full pay for a genuine redundancy at least. But that's all paid by the employer, but then they're not paying a levy on top of that either. Interesting. Okay. Well, here's the results to the third poll. Do you think the income insurance scheme is a good idea? Yes, 44%, which is the highest number of people. No, 28%, and unsure, 27%. So yeah, that will be an interesting one to watch. But as Claire said, it's just an idea at this stage and may never come into effect. All right, we have a lot of questions. We've got 20 open questions, and I think given that we've got 10 minutes left, it's best just to go through them in sort of quick fire fashion, unless Claire and Matthew see anything in the box that really jumps out. Otherwise, so maybe if you have a quick look, I'll throw a few out while you're looking. And these sort of came in as you were going through the topic. So we'll sort of go back to the topic a little and start to address some of the questions. So the first one is, with the expansion in bereavement leave, can a company request proof of bereavement leave, particularly with a miscarriage?
Yeah, and I mean, short answer is yes, it can. So a big rule of thumb is good faith obligations that go all the way through. If someone's saying that they're wanting bereavement leave, I mean, a good employer will take that at face value. But they can't take the mickey as well. You can very politely ask for proof. Very common to ask for proof of funeral notices, those sorts of things, which shouldn't really be too much trouble for an employee to provide. If they are giving you trouble about it, then it's maybe something to look at.
Yeah, a medical note from the doctor is what I would expect.
Yeah, cool. Another question was, what does it mean to earn pro rata sick leave for the first 6 months?
Okay, so that means that you incur or you accrue sick leave on a proportional basis. So, you'll get a little bit of sick leave for each day that you're at work until you 6 months, and then the entire entitlement will come in. So, for the first month, you'll get 1 day sick leave, etc.
Yeah, I mean, one way to think about it is like the way you accrue annual leave, right? If you look at it, if you're an employee, you look at a pay slip, you'll see that it accrues over time. So, once you've been there for example, a month, you've accrued one full days of leave, 2 months, and so on and so forth. The difference, and correct me if I'm wrong, Claire, is that and rather than only being eligible to use it after 6 months, you'll be eligible to use it as it accrues. Yeah.
Yeah. Okay, and that actually, just mentioning payslip, so there was a couple of people asked, did we skip the piece on more transparency on payslips? I think we may have just
I sort of brushed over it, and the requirement to sort of,
So there's more information that needs to be on payslips. The big thing is going to be sick leave balances, because you don't have to put your sick leave balance on a payslip at the moment. And a lot of people don't, because the idea is that if employers see that they've got, a big chunk of sick leave available to them, then they will take it. Where if they don't know, then people might be a little bit more hesitant. But now you do need to put in what your sick leave balance is and how things are calculated. Most businesses will be running some kind of software for doing pay slips, and they will keep up to date with these changes. So,
Yeah. I can say to people on the call that, Employment Hero and KeyPay, which are both owned by one company, will be making all the necessary changes that we can. If they can be accommodated digitally and automated, then they will be within our software. So things like the presentation of a sick leave balance on the payslip, that is something that we will be working on to have it ready in time for when the legislation goes live. Okay, and the next question. Sorry, guys, have you seen any questions there that jumped out? Otherwise, I'll just keep going through in quick fire.
Running through,
Yeah, cool. Okay, what is the minimum age of a young worker on starting out / training minimum wage?
Easy one, 16.
Yeah, 16, easy. So there's generally sort of 3 categories that fit under this starting out minimum wage: 16 to 17-year-olds, first 6 months of employment, and then 18 to 19-year-olds who generally have had some kind of benefit. So being on the dole, some kind of social security that they receive and sort of helping them into employment.
And they also need to be have not worked continuously for 6 months as well.
That's right. And then the other one's sort of industry training. So your apprentices, that sort of thing, in that 16 to 19 age bracket.
And that's official, apprentices, there's no age limit. And it's got to be genuine industry training. You can't just do internal training. It's got to be with some other external parties. So it's apprentices, basically.
Yep, got it. And does the training minimum wage apply to internships?
This is a really interesting question. So internships, the general idea is that if you are just giving somebody work experience and there's no benefit to you, then, and they're like volunteering, then they don't need to be paid. The problem arises where you're obtaining some kind of benefit for the intern, so they're actually providing benefit to your business. So if you give the example of someone coming in as an intern and they're just following around, say a lawyer for a couple of weeks, it's not really any benefit to us, but it's a great benefit to that student, as opposed to someone that comes in and does a whole lot of photocopying. You've got to be quite careful with unpaid internships. We've just recently got the Glory Vale case that came out, which found that even though the children were seen as volunteers, it wasn't really voluntary, and so they were classified as employees. So yeah, definitely be a bit careful around unpaid internships. I'd probably recommend that you get some kind of legal advice around it if you are using interns.
Okay, thank you. And another question that sort of came up a few times was around the fair pay agreements, and what happens if you're already covered by a collective agreement? Will the FPA override it, or do collective agreements override a fair pay agreement?
Sure. Yeah, I mean, so short answer is yes, they would override. It's again the point I sort of maybe touched on about where there are potentially competing fair pay agreements, and same thing really applies to collectives. If there are competing agreements, so first of all, probably oversimplifying the way the process works, but generally you have to try and sort out between the bargaining parties who's actually in the best position to negotiate and who does it cover. So again, those coverage sorts of things. There's a process where you can go to NBIE who says who they think should be doing or giving approvals and that sort of thing. But at the same token, again, when you get to that end point, and if there's a question about competing agreements, it can be left up to the ERA to determine, okay, well, which is better? And so the ERA will actually go through and look and say, make an assessment of which will provide the better minimum terms for employees as a result of the agreement. Effectively, that's the one that will apply. So yeah, again, it's quite a big change from the way things operate at the moment.
It's same topic. So if an employee falls under the coverage area, can they opt out of the fair pay agreement and have their own bespoke employment agreement?
Good question.
You can have better conditions, but no, it's sort of like a floor, you know.
Minimum standard. Yeah. So again, yeah, there is no contracting out under the bill as it's currently drafted. So it applies to everyone. Again, it's that secondary legislation. So those terms will apply as a matter of law. So you couldn't have less for sure. As Claire said, you could have more. Always open to negotiate, but that's the bottom line.
Okay, I think we've got time for 2 more questions. I'll just sort of skip to the bottom just to see if there's some other ones. From what date are the sick leave, accrual, bereavement leave, calcs for annual leave payment and expansion of bereavement leave all taking effect?
Don't know yet because they're not in law.
Okay.
So,
Yep.
Yeah. So watch the space. Yeah.
At present, annual leave is calculated on a 4 weeks. On a 4 weeks leave. At present, annual leave is calculated on 4 weeks leave. Will sick leave be brought into alignment, or will this stay as 10 days?
Oh yes, this is interesting because annual leave is 4 weeks. You know, if I work part time, my week is going to look a lot different to Matt who works full time, right? So, you know, part-time workers will get proportionally less annual leave. You know, they're not going to get 4 weeks or 40 hours. There's a different story for sick leave because part-time workers, so say you only work 3 days a week, you still get 10 days sick leave, and that is not changing. That's not being addressed, and I think that is a massive oversight by the task force, because you can potentially have somebody that works 1 day a week and they get 10 days of sick leave.
Yeah, that makes a lot of sense. Okay, well, thank you, Claire and Matthew, for your time. That brings us to the end. Thank you to everybody for joining us today. A survey will automatically launch after we end this webinar, and we would appreciate if you could take a minute to give us your feedback. We're always looking to improve the way we do this. We will also be sending out some additional resources along with the webinar recording after today's session. I thank you all again, particularly Claire and Matthew from Martelli McKegg. Really appreciate you giving us your expertise, and I hope you all have a wonderful afternoon. Thank you.
Thanks,
Ben. Thanks, guys.